protection trust is like a safety deposit box that allows you during your lifetime to allocate assets such as your home, cash or investments into the trust to protect it. This means that they now belong to the trust. You appoint trustees to manage the trust. Your trustees could be yourself or professional trustees like Thomas Bradley & Co. It is important to remember that you are giving the trustees the discretion to manage the assets and that the assets now belong to the trust and not you as an individual. This allows the trustees to look at the circumstances and manage the assets accordingly during your lifetime or on death. The question you need to ask yourself is why you need a family protection trust. It can avoid the expensive cost, hassle and delay of the executory or probate procedure on death. The executory and probate process can take 6 to 12 months and in some cases much longer. A family protection trust makes this process much smoother and your estate can be passed to beneficiaries in a matter of weeks. Protect your share of assets in the event that a spouse remarries after your death. Should your spouse go into care, it's important you protect your assets from being calculated in their estate. Children have legal rights. If you want to avoid your children emailing us at info@thomasbradleylegal.co.uk.
So just taking it back to the beginning. And it talks about the process, the probate process, like it says it can take 6 to 12 months. When you die, like I mentioned at the very beginning, if what's in your name is less than £36,000, then there can be no need for probate, because your family can take the will and the death certificate and your identification and their identification to the bank, and the bank will give them the money. And if all your other assets belong to your trust, and they're all under that umbrella, because if your house is in the name of the discretionary lifetime trust of Mr. Smith and Mrs. Smith, and the same with your investments and even other money, then the beauty is immediately on your death, when your children prove that you've passed, they automatically become the trustees and beneficiary of the share of your trust that you want them to get. Okay. For a lot of people as well, they worry about, well, what if I die and my husband or my wife marries someone else? Because that creates a complex situation of sideways disinheritance. And the truth is, that's the whole reason these trusts were created hundreds of years ago. And these types of trusts are used even by the royal family of this country to protect their assets and pass them down in the most tax efficient way, but to make sure that your wealth stays with your blood. Because if you passed away and your husband married someone else, if he then dies before his new wife, then she could claim all the wealth for herself, and then when she passes away, because your children don't have the right to claim any of her wealth, then it could mean your children are disinherited, and it creates this complex situation of sideways disinheritance. And unfortunately, a will can't fix sideways disinheritance, but a trust can, and that's the reason why they were created. And like I say, a lot of people worry that if they have to go into a care home in the future, because the way title deeds are set up in the UK, in England, and specifically, that when you own a property together 100%, then if you pass away and your wealth goes to your surviving partner, then if they have to go into care, then the value of their estate could be, when they're means tested, be used to cover the cost of their care. And this is a great way for you to protect your half, and they protect their half against paying your care home fees. Okay, because depending on the type of trust that you do, there's different ways that we can protect it, from paying each other's care home fees from that point of view. And is anyone in a situation that they don't have a good relationship with any of their children or their family? Because the truth is, the only way you can disinherit them is by putting your wealth into trust, because again, that way it doesn't, to reassure you, for you while you're alive nothing changes, it's your trust, you're the trustee, but you're putting in trust now while you're alive to make things easy for your beneficiaries and your children when you die, so that automatically on your death they can get access to the wealth or live in the property or rent it out, sell it, do whatever, but pass your wealth on in the quickest, most tax efficient, safest way to your children. So a will, you can write a will and you can leave your wealth to whoever you like. It doesn't always guarantee that the people that you don't want to benefit from it won't benefit, because again, if the will gets lost or whatever, the government shows them in tests say anyway that the people that have a right to claim it are your direct issue, your children, your blood. Okay. One of the most important reasons for a lot of people creating these types of trusts is to protect their estate against the children inheriting at the wrong time, because sadly we don't know what our children might be faced with in the future. whether it could be divorce or bankruptcy, long-term sick or unemployment. So this is the best way you can leave your wealth to your children to protect it, because like I say, even though you've passed away, your wealth stays in your name to allow them to take it at a time that suits them. Because if it's in your name, it's not in their name, then if they are going through it. And when you do a family protection trust or a testamentary trust, it includes all these other services for the rest of your life.
Right.
So if you
What's
do a
the
family
difference between the first two?
So the testamentary trust gets created on first death of husband and wife, or if you're only a single person, the trust gets created on your death. Okay. And the top one you can create while you're alive, and you can transfer your assets from your name into the trust of your name. So you can actually put your house, investments and even money into the trust. I actually have a short video. Do you want me to play? It only takes 2 minutes.
Yeah, that's fine. Yeah.
Because this might help you to have lots of questions as well. Because when you do that, your children own your property. And if they go through a divorce or die before you, or go through bankruptcy, then you're in a situation that you're very vulnerable, because the house that you're still living in, they could throw you out. Not intentionally, but if they die before you, then their wife could own the property if it was your son that you transferred the house to. But you're creating other taxes, as well, because there's rules on giving gifts, and depending on how much your wealth is, even giving a gift of your property from your name into your children's name, you have to outlive that gift of 7 years. Okay, it's called the 7-year rule. But giving your assets away while you're alive, it doesn't actually protect it from care, because that's another separate issue. The government used legislation called the Cragg Report. So if you try to deprive yourself of those assets for avoidance of care, it's deemed as deprivation of assets. Okay, so they could still come after your son if you've just signed your house from your name into your children's name. Okay, then they can just come to the children and say, well, you had your house, but you signed it over into your children's name to avoid having to pay the care. So they'll make your son pay the care.
Can you gift your house to your children?
Yeah, that's what he said, the 7 year.
Yeah, you can, but it's not advised. It's not a good solution. There's lots of other clever ways that you can plan, because the problem is if you gift your house to your son at zero value, when they come to sell the house in the future, they could have capital gains tax to pay. So you're just passing on the issue to the next generation. And if they already own another property, or when they go to buy and sell property, then they have to declare that they already own other property, and you could be putting them in a situation that they have to pay additional dwelling supplement, second property tax, which is 6% of the value of the new property. So you're just causing more problems. So there's a right way and a wrong way to do everything. If you signed your house from your name into the trust of your name, then legally you're saying the house doesn't belong to me, it belongs to my trust for the benefit of my children. Okay. So it means then when you pass away, automatically on your death, your house belongs to your children immediately on your death. So it means they can sell it right away, and within a matter of weeks they can have the money that you would want them to have from the sale of your house.
So if we doing on that way to house and trust first,
Yeah.
and then what happening, how much the trust take from to the benefit from that?
Nothing.
Nothing.
So you pay to create your trust while you're alive,
Right.
and it's not a coincidence that trust is at the top of the joint bank account with your husband or your partner, or whether it's for your children or whatever. No one can get access to that money, and no one should be taking that money, going to the bank and taking money out, because you're committing fraud. Okay? Because the only person that should be taking money out of that person's bank is the card holder, the person, the account holder. If anyone else is taking money out of the account, then truthfully they're committing fraud. And obviously it's against the law. So by putting power of attorney in place, there's always a right way and a wrong way to do everything. Give the power to the person you trust to allow them to go to the bank and cancel direct debits, put new ones in place, manage your finances, pay your bills, okay? To keep you on the right side of the law. But most importantly, so that you've got someone you trust that can deal with your affairs if sadly you're not able to. So can you see how much more important that can be than a will? Because the government states anyway, if you die and you don't have a will, what the rules are and who's to get what. And I know that might not always go with your wishes, because obviously, as I mentioned earlier, British law states that the children, your direct issue, have a legal right to an equal share of your estate, and under certain cultures and religions, you have your own wishes in terms of how you would like your wealth to go to your family. Okay, so does that make any of you think, oh, I better look at power of attorney?
Yeah, definitely.
It's so important because, like I say, you wouldn't want, for example, social services stepping in and making decisions and end up having to go into a care home. Because for a lot of people in our communities, that's a big worry as well, isn't it? Has anyone had family that had to go into a care home or is in care currently?
No.
Because it's very expensive, isn't it? Do you know the average weekly cost they say today in the UK is to spend 1 week in a care home?
How much?
No.
£1,900 on average.
Oh my God.
So you think every 10 weeks there's £19,000 that you would have thought
Going to
could have went to your children that won't. So this is where things like trust can help to plan for the future as well, to help you to protect your share of the estate against having to pay things like the probate fees, your children inheriting the wrong time, and even help to protect each other's share of the property against paying care home fees. Okay? Because a lot of people in the past have thought that they could just transfer their title deeds from mum and dad's name into the children's name, and as long as they live for 7 years, then there would be no care home fees to pay. Does anyone know this story or?
No.
No.
Okay, so it's the last thing as a legal firm that we would encourage anybody to do is to try and speed up that process, because the process can typically take 6 to 12 months through the courts. But when you have a family protection trust in particular, because your assets belong to your trust and not you as an individual, when you then pass away, your children can automatically become the trustees of your trust immediately on your death. So they then don't have to go through that process that is probate, that can take 6 to 12 months and typically cost anywhere between 3 to 5%, or based on the value of your estate. Obviously, the more money you have, probably the less percentage that the solicitor would charge to carry out probate. But when you think, when it comes to selling your properties as part of selling and winding up your estate to pass it on to your children, I don't know has anyone sold a house recently?
No.
No. Because even estate agents want typically 1 to 3% of the value of the house when you sell it, and also the solicitor can charge anywhere between as little as £900 to as much as £1,900, and then there could be certain taxes involved with additional properties, having to pay capital gains tax and second properties and different things as well. So all these costs that are cost to your estate before your children get any money. Okay. Can I see we show hands? Does everyone have the power of attorney in place?
No.
One person, 2 people. Okay. So power of attorney is in most cases even more important than a will, because the truth is, if you died and you didn't have a will and you're married and got children, the government's rules of inheritance already state who has a right to claim your estate, and it just means they're going to have to go through an additional process to claim your estate. But your will only comes into effect when you pass away, when you die. Power of attorney is something that you should put in place while you're alive, so that if you take ill, where you have a stroke or get dementia or Alzheimer's, or you just physically can't leave your property to go to the bank and deal with your own affairs, power of attorney can be so important, even more important than a will, because it's all about what happens to you and your wealth while you're alive. It's all about you giving the power to somebody you trust to allow them to step into your shoes to make all decisions on your behalf if you're not able to. Whether it's dealing with health and welfare decisions through medical professionals, social services, or whether it's dealing with your finances, okay, or your property. Because when you own a property in England, and if both husband and wife are on the title deeds, joint tenancy means you own the property together. And unfortunately, if one of you had a stroke or was in a serious accident, then without power of attorney, if your husband had a stroke, then if you needed to sell the family home, without power of attorney, you couldn't sell your property, because it would take both of you to sign to say that you're happy to sell the property. So one of the most important parts of estate planning is power of attorney. Like I say, there's 2 parts: health and welfare and finance and property. Because that's you giving the power to somebody, like I say, you trust, to step into your shoes to make all decisions on your behalf as if it was you that was making those decisions. So that if you ended up in hospital and you took ill, rather than having social services step in and take control of your affairs, it keeps you control within your family. Can you see how important that could be?
Yeah.
Okay. Power of attorney has to be registered at the government's Office of Public Guardian. It's a very legal document. That's the problem with basic wills, is it just says when I die, give my money to my children. So a lot of people look at it today as if you're forcing your wealth on your children when you die, because we don't have a crystal ball, we don't know what's going to happen in the future, and we don't know whether our children may be going through a divorce, maybe bankruptcy, long-term sick or unemployment where they could be in receipt of benefits. Because, as an example, if you left all your money to your son and he was going through a divorce, then it could be a situation that his future ex-wife's entitled to some of the inheritance that you're leaving to your son. If your son's going through a divorce because he's had his own business or his own company, or he's got himself into debt, then the money you're leaving could be taken to cover the cost of his debt. And sadly, if he's on benefits due to ill health or because he's unemployed, then by forcing your wealth onto your son, if, as an example, he was getting £15,000 a year benefit and you left him £150,000, then he'll have to tell the DWP that his circumstances have changed. And it could mean that he could lose his benefits for the same length of time that money would have to last him. So if he's getting £15,000 a year benefits and you leave him £150,000, then he might not be able to claim his benefits for the next 10 years. So this is where things like trusts come into play. Because this is just clever estate planning. Because rather than forcing your wealth onto your children and making them take a cheque, the trust allows you to leave your wealth to your children in trust. So the money stays in your name even though you've passed away, sadly. Okay? And it means that when you do pass away, your money stays in your name for the benefit of your children in trust. So that then allows your children to take the money from your trust that you've left them at a time that suits them best. Not when they're going through a divorce or bankruptcy, long-term sick or unemployment. Because the money that you're leaving them is still in your name, they then don't have to declare it. Does that make sense?
Yes. Yeah.
Okay. The benefit of trust generationally also allow you to pass your tax benefits on to your children. Because if they keep the money in your name and your trust and they take it when they need it or use it to buy property in the name of your trust, then they can also create their own trust with their wife, and they can also pass on their trust and your trust on to their children with both sets of tax benefits. Because cleverly, if your total wealth today was £3 million to leave to your children, and you had 3 children and you're thinking, great, my children will get £1 million each. The truth is they wouldn't.
It's not, yeah.
Because when your wealth as a married couple goes over £2.7 million, you lose that residence nil rate band of the £175,000 each for your main property. So your tax-free allowance drops then from £1 million down to £650,000. So the government would want to take everything, 40% of everything between £650,000 to £3 million. So you can imagine you're talking nearly £1 million then in tax that your children would lose. So it can be devastating to all your hard work and effort that your family and all the wealth that's been passed down. So if mum and dad create a trust and leave it to the son, and if son's wife gets a trust from mum and dad, then the 2 trusts that came from the parents, when you've created your own trust and got a trust from your own parents and you leave that onto your son, then you're passing 3 trusts with 3 lots of tax benefits on to the next generation, the grandchildren. Does that make sense? Okay? Because then that way, £1 million in trust and £1 million in trust and another £1 million in trust, that's the only way that you can pass £3 million on to the next generation without having them to pay inheritance tax. So it's the only way you could pass that £3 million on to your children without them having nothing to pay. Certain trusts as well can also make it that the process that your family have to go through, that probate process, £5,000 each, and both residence nil rate bands of £175,000 each to your children, giving you £1 million inheritance tax free. And that's what it is currently. Obviously we've got an up and coming budget and it could be changed again, so as it stands today, that's what the inheritance tax rules are. So if you have wealth more than £1 million, then the lady mentioned 40%. It would mean that when you pass away and the process of probate begins, the first thing that has to be established is there more wealth than £1 million, and is there likely to be inheritance tax to pay? So if there's more than £1 million, they have to do the calculation. So if someone was to pass away with 1,200,000, 1.2 million, then the £200,000 that's over the £1 million, that's what's liable for inheritance tax at 40%. So it means that your children or your beneficiaries, the people who are benefiting from your estate, they have to actually pay that tax before they can claim your money. Okay? So on 200,000, that means if the government wants 40%, that's 40,000 in every 100,000. So if you're 200,000 over, the government, the HMRC are wanting £80,000 of that 200,000. So your children are not going to get 1.2 million, they're only going to get 1,120,000. Okay? But obviously you've got other fees on top of that for the probate fees, where the solicitor will charge, for probate to sell the property and everything, to gather all the wealth in, to give your children that cheque. To claim your estate, your children, your brothers and sisters, if you don't have any children, it's up to them to respect your wishes. Okay? But in certain circumstances, they might not respect your wishes because they want to claim the share of your estate that they're legally entitled to. And that gives them the power to contest your will. Okay? So this is where we have problems. So this is where other protection comes into place, because truthfully a will just says, when I die, give my money to that person. And if you think about, we don't know about what's going to happen in the future. The only thing it's certain is there'll come a time when our life ends, and such a sad time, we want to make things as easy as we possibly can for our children. And that's where, by planning properly, the more you plan today, the less your children will have to go through when you pass away at such a sad time. Okay? So that's why it's important to have all these things in place, because the more you put in place, the easier you're going to make things for your children in the future. Because it's important to have a will, because if you do pass away and your wealth is more than £36,000, your children are going to need that will to carry out probate. Okay? I'm going to talk about what you said about the 40%, okay? Because that's my area of expertise, the inheritance, okay? Because a will doesn't stop things like inheritance tax. Even trusts don't stop inheritance tax, okay? So the whole point of inheritance tax is, as an individual, we'll have tax-free allowance to pass on to our beneficiaries, okay? Now, the amount of tax-free allowance you have depends on certain things. If you're a single person that doesn't have any children, then currently your tax-free allowance is 325,000. So that means the first 325,000 of your wealth can be passed to your beneficiaries with no tax to pay. Okay? If you're married and you have no children, then you get to claim each other's what we call nil rate band. Okay, your tax-free allowance of 325,000 each. So if you're a married couple with no children, you have 650,000 to leave to your children with to your beneficiaries with no tax to pay. Okay, if you're married and you own your property and you have children, you get a further tax benefit of £175,000 each. Okay, that's known as your residence nil rate band. Okay. And that only applies when you have children and you have a main residence, a property that you own. Okay? Irrespective to whether you have a mortgage or not, that doesn't make any difference. Okay? But it allows you to leave in total then.
So if parents passed away,
Yeah.
at least something on the paper that
That says this is what the parent wants.
yes, yeah.
Fantastic.
I was going to say, also, if you do everything for your children, and if you don't have a will in place, it's 40% will go to the government, and then obviously it's to avoid that big.
So these are the important. These are important. These are important reasons why we ask these questions, because the truth is what you just said is not actually true. Okay?
Right.
But it's so important to have these sessions to help people to understand that what really is the truth.
Yeah.
Because, you know, there's lots of information out there, but sometimes it's a minefield and people don't know where to go, and, you know, someone will maybe ask a friend and the friend, you know, thinks they might know the right answer, but, you know, but they don't really know the truth. So this is your opportunity when you have a professional that, you know, knows what the law is and the benefits of all these things to give you the best advice. Okay? So a lot of people don't really understand the reason why we need a will. Okay? So I want to start there and I'll work up the ladder and give you, and you can keep asking questions as well. But the reason why people need a will in England, okay, because the law in England is different to the law in Scotland, okay, because when you die, if you have wealth that's more than £36,000, that's the reason why you would need a will. Because when you die, if your wealth is more than £36,000, even though your will states who you want to benefit from that wealth, the government want an opportunity to look through your finances 7 years before you die. And have you heard of the word probate?
Yes.
Okay. So when you die, because your wealth is more than £36,000, your family need the will because they'll have to go through probate to claim your wealth.
Yes.
Okay. And typically that process can take anywhere between 6 to 12 months. And lawyers, they don't all charge the same money to carry this process out. Okay, they can typically charge between 2 to 5%, plus VAT, plus outlays, plus the cost of selling your house. So all these things are costs that come out of your estate before your children get any money. Okay, so that's the reason why you need a will. Is
Well,
Tell everybody to turn off the mobile.
Can everyone please put your phones on silent? I am down. Thank you.
So, like I say, if you have wealth as an individual more than 36,000, that's why it's important for you to have a will. Okay? And in your will, it's important for you to name. Does anyone know what the word or who an executor is? The executor is a person that you appoint to execute your estate, to carry out your wishes. Okay? And when you write a will, you also name what's called beneficiaries. Because beneficiaries are the people that you want to benefit from your wealth. Okay? And I understand in many cultures and religions and everything, and different faiths, people have different ideas of in their family who gets what. Because I understand in a lot of Muslim cultures that sons get 2 shares and daughters gets 1 share.
Yes.
Yeah,
Which is correct. Okay. Whereas the British inheritance tax rules state that if you live in the UK and you're domiciled in the UK, then under British law, your children all have a legal right to an equal share of your estate. Okay? So this is where, when we talk about protection, a will doesn't really protect your children from anything. It just states, it's a legally binding expression of your wishes that state, this is what I would like to happen when I pass away. And it's